Hi, this is Ben Jackson with the Illinois Bankers Association. I want to provide you an update today on the Illinois Community Reinvestment Act. That's a law passed a couple of years ago in Illinois that piggybacks onto the federal CRA, but it also applies, in addition to state chartered banks, to state chartered credit unions and residential mortgage lenders as well. We're in the rulemaking phase for that law. We've provided some updates on that over the past couple of months to our members, but definitely appropriate today to give you another update as there was an administrative hearing on the rules today in Chicago. The IBA attended that hearing, and over the past couple of months, we've been advocating on behalf of our members in the rulemaking phase to make sure that this rule is the least harmful to state chartered banks in terms of their operations and hitting their bottom line as it can be. The law is the law, but we are working to make it better for our members. A couple of things to mention where we've been successful in negotiating this rule to a better place for our state chartered banks. One is the second rule proposal that we saw from the agency commissioned a disparity study. It would have targeted a few high-performing banks in Illinois and looked at their lending activity in comparison to their CRA rating. It then would have taken results of that study and applied its metrics to all banks, all credit unions, all mortgage lenders. That is problematic for a couple of reasons. First, it targeted individual members for additional scrutiny not authorized by the state law. And it also would have held other banks that weren't partaking in this study involuntarily to be subject to the results of that study and the measures developed through that. That was incredibly problematic, and we worked really hard to remove it. At this point, we're pleased to report that it has been removed, along with some other provisions that we found problematic after talking with our members. Something else that was removed on that list includes a reference to Section 1071 of the Dodd-Frank Act. As bankers know, that is a law that's going through the federal rulemaking phase at this point to require collection of small business lending data by banks, submitting that to their federal regulators. This would have layered on an additional requirement for state chartered banks to report that same data to state regulators. That was removed. Also removed was language permitting state regulators to examine bank affiliates, particularly problematic for those affiliates of banks that are not lenders, essentially, insurance subsidiaries, affiliates, things of that nature. That was removed as well. There was also language permitting the state agency to examine certain national banks' Illinois operations. Obviously a huge problem, major preemption issue. That was removed as well. So where are we on this law and these rules implementing this law? As I mentioned, there was a hearing today. JCAR, which is a bicameral, bipartisan legislative body, listened to testimony from our state regulator, the IDFPR, on this rule. The committee concluded that it wasn't quite ready yet, that the agency continued to need to work with groups like ours, as well as separately with the credit unions and the residential mortgage lenders to get these rules right. So that gives us into the beginning of 2024 to continue negotiating these rules. But we do think that likely the next JCAR hearing, administrative hearing that takes place, that these will be taken up, likely in January or perhaps February. So these rules will be finalized soon, but there's still a window to work on them a little bit. So what are we doing? We're still taking feedback from members to see if there are, additional discrepancies that need to be addressed, and we're working on fees. The state law authorizes the agency to collect fees to conduct these exams. The first fees that were put into the bill were very problematic. They were daily examination fees, very high rate, and they automatically increased by 5% per year, up to 5% per year. Where we're at on the fees right now, a couple of victories there. One is removing the automatic increases. So those are gone in the rulemaking proposal that's out there now. Second, a shift away from the daily fees, which even for a very small bank could run up into the tens of thousands of dollars very quickly, because CRA exams, we understand from our members, take a long time. That was removed. We still have issues with the fee proposal because we don't know how much the department really needs to implement this. And we obviously want to keep these fees as low as we can for our members, so it's not an additional burden on them. So that's one issue that we're still working on. Another issue is coordination of exams between federal examiners and state examiners. That's been difficult to establish. It's discussed in the law, it's referenced in the rule, but we don't have much concrete evidence that that is going to work out, that federal and state examiners are going to go into exams together, work together on examination reports as well, and also in the process of assigning ratings. So those are some lingering issues. Please reach out to us. We'll put information on how to reach us in below this video and through our social media accounts. So please reach out if you have further comments on this. We'd love to hear from you. We're happy to share the latest draft if any bankers want to take a look at it. And thanks to everyone who reached out to us about this rulemaking proposal as we've worked on it over the past few months. Thanks.